CS number
54/26 dated 29/7/2026.
learned counsel for the petitioner submits that the petitioner shall appear before the learned court below and file appropriate application. Accordingly, the matter stands closed.
Please, Your Lordship. I beg to mention item number 35 of the case list. Lordship, in this case, a report was called for from the Sibsagar police station.
Monday, Lordship, because we have not received, but they will inform us. They have informed us. Wednesday, Lordship.
35.
35, Lordship.
That report as called for has not been received. List again on Wednesday.
Interim order is there, Lordship.
Interim order to continue till the next date of.
Black.
Please, Your Lordship. My lord, item number 41, my lord. Yes, CD was called for, probably it's not received, my lord.
Forty-one. Forty-one not received, Lordship.
Interim is there.
Not there.
Hmm?
Not there, my lord.
List again on Wednesday.
21.
Please, my lord. My lord, I beg to mention item number 45, my lord, on behalf of my senior Mr. S. Samaria, lordship. I'm just preparing for a short accommodation of 1 week time, lordship.
All right.
Lordship, is because this the trial court record is there that let the matter maybe come for admission, lordship.
Is the matter so for admission?
Highly obliged, lordship.
May it please your lordship, I beg to mention item number 51. Kindly pass over it for today.
Good. We did.
Highly obliged.
May I please your lordship, I pray for adjournment of item number 16 for the day with the consent of the other side, your lordship.
16. On the other side.
Yes, your lordship.
Please, Lordship. Lordship, item number 40. CD is not available. May kindly mention for the day.
40 CD is not available.
All right.
All right.
You are Mr.
A Tarafdar, appearing on behalf of Mr. S. Das, Surajit Das.
Sir, A Tarafdar.
A Tarafdar,
Appearing on behalf of Mr.
S. Das, Surajit Das, lordship.
Das. Place for withdrawal of the instant application. Hence dismissed on withdrawal.
Chiefly of Lordship.
Item number 1.
May I please, my lord? In this matter, my lord, may call for the case diary, my lord.
All right.
এটা বস্তু ভুল হৈছে পানিশমেন্ট এটা 7 বছৰ হৈ থকা নাই 10 বছৰ হ'লে কিনে এই নোটিছ মানে 20 অলপ 20 ইসিটো টাইম লাগে 20
Obligement.
May I please lordship, commercial quantity lordship. CD may call for lordship.
May it please your lordship. Lord, it is regarding the cows, my lord. So, my lord, cows are seized, my lord. vehicles are seized. And petitioners were arrested, they are in custody for 23 days. my lord. So my humble submission before your lordship, entire case is on material documents. my lord. All are seized, my lord. Further detention of the petitioners not necessary. Let my humble submission before your lordship, cows are purchased cows. I have given the money receipts, my lord, regarding the entire cows. my lord. So, my lord, it is said that it is stolen articles. It is not stolen articles. my lord. I have given the entire money receipts, my lord, against the cows. It is a purchased cows, my lord. From one market, it was transported to another market. On road, it was seized, my lord. To my humble submission before your lordship, further custodial detention of the petitioner is not at all necessary. My lord, CD is not necessary, my lord. Nothing will, no new things will come. Entire case is on materials evidence, my lord. All are purchased cows, my lord. And in the section, my lord, it is alleged that it is stolen cows and stolen properties. Not stolen properties, my lord. Not, no theft has been committed. Entire thing on record, my lord. Already, my lord, they have completed 23 days. Further custody is not necessary, my lord. My humble submission will be urged. And from one district to another district, as per Cattle Preservation Act, my lord, no permission is necessary. It is from Borbata to Dorong. Transportation. From one market to another market, my lord. No permission is necessary. No license is necessary. Scissor list I have annexed with the case, my lord. My lord, at the time of interception, my lord, I have produced the money receipts against which we have purchased the cows, but police was not ready to hear anything. They told that it is the stolen cattle.
What is the capacity of a vehicle?
My lord,
As per rules, how many can you carry?
my lord, regarding that, this is regarding cruelty, my lord. Cruelty invites only fine, my lord, not anything else. Section 11, my lord, that cruelty against animal, it is only fine imposed. There is no question of arresting. Fine can be imposed if there is without capacity something. That is also a statement of the policeman. What was the capacity? That much of cows were taken. Anyhow, my lord, if that offense is committed on the facts and circumstances of it, only fine can be imposed, my lord.
Lordship, it is on Kamrup, Lordship. Short date, we'll bring the CD now.
My lord, CD, my humble submission before your lordship, for call for the CD is not necessary.
Call it next week, CD.
My lord,
CD, next week. Give it next week.
in that case, my lord, interim bail may be granted to me. To the accused persons, my lord. From the materials available on records, my lord. CD will not bring new things, my lord. Interim bail may be granted to us, my lord.
Have you seen the CD?
My lord.
Have you seen the CD?
No, my lord. Your lordship would be pleased to see the
We have seen a
materials.
lot.
My lord.
We have seen a lot. That is why.
Your lordship seen, but my submission is not considered by your lordship. Because, my lord, cow has been seized, my lord, receipts is there. We are in 23 days in custody. Not that, my lord, in every case, CD is necessary, my lord. That is my humble submission before lordship.
Yes, we have considered.
Yes.
Much obliged, your lordship.
May I please your lordship? This is in 483 in application, lordship, FIR page number is, page number 13. FIR page number 12, lordship. Allegation is this, the petitioners planning to commit an cyber offense, lordship, three numbers of co-accused already released on bail by this honorable court before 3 days ago, lordship.
What is your name?
Asraful Islam.
Lordship will have to go to the city because what is his role, Lordship?
So, lordship, my lordship,
will be
the
clear.
main, as per the disclosure of the main accused, my name is firstly implicated in the event. Main accused already released on bail, lordship, by this honorable court. Earlier 3 days ago, 3 days received by this honorable court after seeing the CD, two numbers of accused released on anticipatory bail, lordship. 3-year bail, lordship, and receive page number 29, lordship. Page number 29.
Yeah,
11%.
You are specifically described here in the FIR down below. It is found that Asraful Islam so and so is an active member of the cyber fraud syndicate. Petition was filed against him. Accordingly, the entry inquiry conducted revealed incriminating material against him. It's specific to you.
So everything was already recovered. Lordship, everything is behind the more than 1 month. All item already seized by this by the police, concerned police. Others co-accused the person already.
Next week,
Lots of
shortly.
things are recovered from them, but they are already released in anticipatory bail, lordship, by this honorable court, lordship. And you see the page number 22. Lordship, 11% is page number 23. 20, page number 20, 29, lordship.
This is a different case. 22 is regarding delayed production on technical ground.
Lordship,
You have to make out on your own if that ground applies to you.
petitioner, the police also seize items from their, lordship, from them, lordship. But they are released from bail, lordship. Anticipatory bail, lordship. Petitioner behind there are more than
Which
one,
page are you referring to?
lordship.
Which page are you referring to?
Page number 30, lordship. Lordship, para 5. The Lawrence or counsel for the petitioner submit that at best, whatever has been alleged against the petitioner is that he was preparing to commit some cyber offense. Even assuming the same to be true, that does not constitute any offense. Moreover, whatever material was required to be collected has already been seized by the investigation officer. The petitioner is ready to cooperate with the investigation. Furthermore, co-accused of the one Azharul Islam has already been granted bail by this honorable court dated 3/8/2026 in bail. Lordship, investigation already, they have investigation already seized the materials, Lordship, more than 1 month behind the bar. The number of cases already released on bail. The allegation is that the petitioner planning to commit a cyber offense. They have not committed the offense, Lordship. The materials already recovered, suspected materials. The petitioner also not arrested from the elect place. They are arrested from their own residence, Lordship, after disclosure of the main accused. Main accused already released on bail by this honorable court.
Sounded, Lordship, next week, Lordship. Because he's
Lordship,
the main.
Petitioner has this serious health condition, Lordship. They are admitted to hospital. Three numbers of quick is already released, two numbers of already released in PLS bill. No incriminating material has been recovered from the petitioners. They have some two mobile phones and two bank passbook from their residence.
Subsequent to that, there may have been recovery. We don't.
So already recovered, Lordship.
There is.
Lordship already recovered, all materials already recovered, more than behind the more than 1 month.
Let's have it on Wednesday.
Okay. 19,
17th.
17, no, Monday. 19.
May it please your lordship. Lordship, NBP's commercial quantity matter. There are certain averments with regards to the arrest and the entire procedure. And he's a driver. CD may be called for at this stage, your lordship.
अब कितना जा रहा है ना? 24 months. 26. 26.
Deeply obliged.
Your lordships, petitioner is behind the bar for last more than 14 days, your lordships, in a case, he has been lost against, she is an informant in this case, but subsequently she has been arrested, your lordships. Being a lady, your lordships, two boys who is 9 months, one is 9 months old, your lordships. She has been arrested, some regarding the two persons, the president and secretary of one BRC has been misutilizing fund.
What, 56 lakhs?
Lordships, because she has been arrested at midnight, and the relative of the husband, the copy of arrest memo has been served upon the husband at around 1:50 p.m. And she has been taken, and ground of arrest has been served on 4:30 a.m. on 2/8 August, and took her to medical examination at the morning hours. So from the things of the series of thing has been conspired that she has been arrested at the after sunset, and without taking permission from the chief judicial magistrate, which is very much necessary. A breastfeeding woman has been kept in a police custody for 4:30. It is stated that she has been arrested 4:30, but she has been done medical examination after 11 hours delay. 4:30. 5:30. Why she has been kept in under police custody for last more than 11 hours? The BNSS provision has specifically stated as soon as possible she may be kept. The arrest memo has been served to the relative, and she has been forthwith to the sent to the for medical examination. But the thing has been done in such a way that she has been gone to the produce medical examination done at the morning hours, your lordship. And there is no incriminating material has been recovered from the petitioner, though she is an informant in this case. There already materials has been seized, and she has already been cooperated with the police station. And the main accused person themselves admitted that they have committed the crime and they will repay the entire amount. And I have annexed all the details, your lordships. Their undertaking, your lordships. Their acknowledgement, which is annexed as page 72, your lordships, of my application. most of the time I was on maternity leave. And the
Yes, very elaborate.
Her involvement is there, Lordship. Major involvement is there.
He's the main person.
Lordship. So, Lordship, CD, Lordship.
Yes, CD.
Bongaigaon it is. 27.
Lordship.
Petitioner arrested on 27/7/2026 along with the cattle vehicles. So, my lord, actually they are the purchasers.
All right, CD.
CD.
My lord, software may can be given.
Kamu. 24.
May I please your lordship? Lordship, the present case is related to special NDPS case number 10 of 2026, which is pending trial before the special judge Sibsagar. Your lordship, a case of intermediate quantity of ganja. According to the prosecution, 12.175 kg of suspected to be ganja has been seized.
How long?
Sarseted, Lordship.
Yes, sir.
This year.
Lordship, I have been in the Sibsagar jail for the last 164 days.
Let the TCR be there, Lordship.
So, Lordship, I humbly submit that a prayer for interim is also made on humanitarian grounds. Lordship, the wife of the petitioner, she is in advanced stage of pregnancy, around 31 weeks. Moreover, Lordship, the scenario currently in the Sibsagar district, they have waterlogging there. They have been victim of circumstances. So there is no male person currently at their home. My father, my father has also been arrested in this case on 15th of February 2026. Thereafter, 2 weeks later, I have been also arrested from my home on 1st of March 2026.
Where is the FIR?
Case number 18, Lordship.
Lordship, the
In translation is in 22, Lordship.
They have
ganja
annexed
has
the
been
charge sheet
seized from
also already.
Lordship.
ganja has been seized from the premises of the garden of my father's house. I was not present at that day of the time of seizure. Lordship, previously bail has been paid before the special judge, Sibsagar district. Wide order 19/5/2026 has been held that twin conditions of section 37 is not fulfilled. However, most respectfully, I submit, Your Honor, that in the present case, since it is intermediate quantity and the other sections are 20, 19 and others are not applicable. Hence, it may, is a rigors of section 37 may not be applicable in the present case. The order is annexed.
This year, along with the CD lordship, then it will be, if there is nothing, then lordship, we will get the benefit then. Because it is hidden in his garden area 12.175 kg. Premises of his house, lordship. From two separate locations, it was hidden in a garden area outside of the house.
Your Lordship, I humbly submit that further custodial detention may not be warranted as it has been suscited and it has been more than 160 days, 164 days on today's date. And my wife is also.
He was not present. He was not present.
Lordship, but it was in
His
whether he is.
But his father is arrested, then
It may be lordship. So let the CD, along with the CD lordship.
I think he has spent enough. We'll call for it, but we'll
Lordship,
let him go for now.
Lordship, I humbly submit that
Only one.
Learned counsel for the petitioner and learned additional PP decision under so and so. The allegation is contained in the charge sheet is that the total quantity of about 11 kgs of suspected ganja was recovered. House compound of the petitioner. It appears from the charge sheet that the father and mother of the petitioner were present in the house at the time of search, but the petitioner was not present. Para the CD, having regard to the fact that the petitioner has been behind bars for the last 164
today's date it is 164 days, Your Honor.
days. That the petitioner be released the interim bail of rupees 50,000 with 2 securities to the satisfaction of the learned trial court. Order directed that the petition, provided that the petitioner shall not misuse the privilege of bail. List again on so and so.
Registry. Lordship through registry. This year through registry.
But this year,
Yes, Lordship.
May I please, Your Lordship? My lord, this is a regular bail application of two brothers, my lord. Here mitigating aspect of this matter is that, my lord, from the date of, my lord, alleged incident, my lord, they are, my lord, exposed for, my lord, investigation, and since then, my lord, they are in jail, my lord. And once, my lord, this learned trial code, page 22, my lord, it was fixed for, my lord, default bail, my lord. Kindly, Lordship, have a look, page 22. CD was produced and date was fixed, my lord, on 3/6/2026 for granting, my lord, default bail, my lord. But immediately thereafter, my lord, IO, my lord, taken back the case diary, my lord, and on 3/6/2026, my lord, it was found, my lord, case is charge sheeted, my lord. Then this petitioners before your lordship approached, and this honorable court directed, my lord, to pay regular bail before the trial court. Page 31, my lord, annexure 4. And accordingly, my lord, they submitted bail application. Then, my lord,
ultimately, charge sheet has been submitted within the period.
period.
All right. Now,
One-
so on merits. Is it not?
Yes, my lord. One is granted bail, my lord, page 33, after approaching dishonorable court, my lord, and others rejected, my lord. But there is no, my lord, sufficient ground is shown, my lord, only just rejected.
Did the scan copy be
Page
there?
35, my lord, last rejection order. Annexure 6, my lord.
103, Lordship, it is.
After charge sheet, my lord, they are still, my lord,
103, oh, it is here. Yes.
sublime.
Leonard friend was supposed to file affidavit, my lord.
Lordship, here the signing authority was involved in a ongoing raid since yesterday afternoon. Lordship, he will be coming today. Lordship, one day time, Lordship. Lordship may take it up on Monday.
No, my lord, I need to file my response also, my lord. At least 7 days time, my lord, so that I can also file, because I am told that another FIR on the same subject has been mentioned. All these things I will bring by way
All
of
things
affidavit.
I have brought on a affidavit, Lordship.
At least, my lord, opportunity may given to respond to that also.
Lordship may take it up on Wednesday, Lordship.
Friday, my lord.
He can
Oh,
also-
Friday, what is it? Submitted by Mr. Chaudhary, Learned Standing Council Finance, that the affidavit is on the verge of being submitted. Praise for listing of the matter on another date. Learned Counsel for the petitioner submits that he would be filing his response there too. Hence, list the matter again on Friday.
Interim order may kindly continue.
Interim order passed earlier to the next date of list.
Deeply all right.
Lordship, item 60 is also connected, Lordship.
Is the regular bill, my lord. I am the lady. On the last date, my lord, state was to be made party. So accordingly, I made a party, my lord, to the state. And
Lordship,
to that effect, my lord, there is a two guiding judgment of the apex court, my lord. Small judgment, lordship, kindly have a look, my lord. It is all, my lord, documentary evidence. Documentary evidence, my lord. Documentary evidence, there cannot be any thing, my lord. The basically is a complaint case has been filed, my lord. Lordship, kindly have a look that two judgment, my lord, small judgment.
Before we go to the judgments, we have to be apprised of the facts.
Yes, yes. The facts is that, my lord,
Yes.
Lordship,
a
here,
complaint was filed.
Just a moment, he has some submission to make.
Lordship, here, a case report I have received, but after going through it, it's not complete with regard to the petitioner. Lordship, I pray Lordship may take it up this matter on Wednesday or along with the
My lord,
other
I am behind
item
the
on
bar.
Friday, Lordship.
I am behind the bar, my lord. It is all the documentary evidence, my lord. Lordship, kindly have a look at page 17, my lord.
We need to verify.
My lord, I am the lady and I am the behind the bar. I was under treatment, my lord, for which I was being arrested, my lord. And they have taken all the documents, my lord.
Fault lies on you. You
And
made the wrong
nothing have been
party.
recovered from me, my lord.
It is because of you that the matter got delayed. Fault of counsel. You made the wrong party.
My lord.
List on Wednesday.
Tuesday. My lord, instead of Wednesday, my lord, can it be on Tuesday, my lord?
Why?
Because, my lord, on the Wednesday, there will be other motion cases for me, my lord.
So,
I'll be preoccupied in another court also. Only one day before, my lord.
Lordship may take it up Wednesday as a fixed item at 2, then he can reschedule his program.
At 2, pick up, my lord.
at 2. List them as prayed for by Learned Standing Council. Is the matter.
Worship matter may be passed over for the time being. It's on legs.
Wait, please, your lordship. But Cadillac, my lord, FIR is at page number 14. Two numbers of cattle were allegedly recovered from the private vehicle of the present petitioner, my lord. He is the owner of the vehicle. Page number 14, my lord.
One I-20 looks.
Hmm?
The vehicle is Hyundai I-20 looks. I-20 vehicle. Vehicle, 2 cows were transported looks.
The cattle were already recovered, my lord. And
Alright, CD. Yes. This has become a plague,
Cows have become
This
passenger also.
cattle smuggling.
highly obliged.
Copy may be called for looks.
Charge sheeted, madam, my
Scan copy of C.
from Sri Bhumi Karimganj, Malo. My respectful prayer will be for a fixed rate, Malo. Today is hopefully. I'm deeply obliged.
May I please, your lordship. My lord, in the FIR, my lord, as many as 6 accused, my lord. I am for the accused number 3. My lord, what happened, my lord? 108 cows, my lord. Cattle was purchased from the local market by the accused number 1 and 2, my lord. My lord, the cattle, my lord, already seized by the police. And I am, my lord, I am a, my lord, clerk, my lord, advocate's clerk, my lord, practicing here, my lord. He is, my lord, clerical job doing, my lord, since 1999 under me, my lord. My lord, he is not at all connected with the offense, my lord. Your lordship kindly see the FIR. FIR, my lord, only suspected person. My lord, last line, my lord, below, my lord, page 13, my lord. Page 13 below. During operation, Mehtab Ali, he is, my lord, arrested. Son of so was apprehended from the spot. However, other persons suspected to be involved in the said, my lord, offense, my lord. My lord, I am, my lord, advocate's clerk. I am doing my clerical work here in this court, my lord, since 1999, my lord. He is under me, my lord. My lord, your lordship kindly see, we are the 3 brothers. My lord, we are residing in separate campus, my lord. My lord, at the time of my lord Caesar, my lord, all the cows are found in the house of the accused number 1 and 2, my lord. Accused number 1 already, my lord, arrested. My lord, my humble submission before your lordship, my lord, I may be protected, my lord. There is no other any alternative way, my lord.
I have no
My lord,
objection also.
license, your lordship kindly see page 31, my lord. My lord, translated copy, my lord, 32, my lord. My lord, this license may be considered, my lord.
Yes, PP, what is against him?
Yes, Lordship will kindly come to page 16, the forwarding. I'm skipping the
Yes.
entire part, Lordship. I will also not read the brief of the case. Lordship will kindly come to page 17, grounds of arrest. Point number 3, Lordship. During the search, 99 cattle were found tied inside the premises of the accused person, and another 9 cattle were found loaded in Ashok Lane and vehicle number so and so, making a total of 108 cattle recovered
Yes.
from the place of occurrence. That approximately 343.83 kg of suspected raw beef was also recovered from the premises in different stages of processing. Regarding him, Lordship will kindly see Annexure 3, Lordship, page 19. This is the seizure list. 6-wheeler Ashok Leyland vehicle loaded with 9 live number cattle covered with blue tarpaulin. Then, Lordship, Annexure number 3 series, Lordship, page 22.
From other co-accused lordship, raw meat suspected to be beef meat of approximately 343 kg lordship.
Maybe, my lord. I'm admitting, my lord, everything I'm admitting, my lord.
CD may be called for lordship.
My lord, my lord, my learned friend is submitting, my lord, I'm admitting, my lord. My lord, I am not connected at all, my lord. My lord, I am an advocate's clerk, my lord. My lord, what is the connection with them, my lord? They are residing in the separate room, separate mess, my lord.
Advocate's clerk lordship doesn't mean that he will not commit an offense.
No, my lord,
That
my
cannot
lord,
be
my lord, as
At
per
least
my
the CD will
instruction,
be
my lord,
produced.
he is doing the clerical job under me, my lord. My lord, he has firmly said, my lord, no, I am not at all connected, my lord.
By her silently lordship, we can produce the
My lord,
case that
your
is
lordship,
next week.
your lordship kindly see the purchase, my lord, memo, my lord. They have purchased, my lord, from the local market with the intention to sell those, my lord, cattle in another local market, my lord. My lord, they are doing their business, my lord. I am hearing, doing my clerical job here in my lord. My lord, what is the, my lord, connection with them, my lord? They are residing in a separate room. I am residing under separate group, my lord, separate mess, my lord. My lord, humble submission. I will cooperate with the investigation, my lord. My lord, since my lord, I am, my lord, considering the, my lord, my license, my lord, I am doing, my lord, calicut job here in this court, my lord. My humble submission. I will cooperate, my lord. My protection may be, my lord, considered, my lord.
Next date I will produce lordship. Next week itself.
My humble submission, my lord. My lord, I have no other alternative way, my lord.
Other alternative means what? No other alternative.
My lord, I am seeking, my lord, protection, my lord.
But as per seizure list, your name is there.
My lord, exactly, my lord. Since my lord, adjacent plot, my lord. Adjacent plot. My other two brothers are living, my lord, adjacent plot, my lord.
Lordship, it is a coincidence, lordship.
My lord.
In one premises, 300 kgs of raw beef meat was found, and in his compound, lordship, around 100 cattle were found, but they have no connection. So it's a
My lord,
coincidence, lordship.
my lord, your lordship in the Azahar, my lord, nothing, my lord, against me, my lord.
All are related, lordship. At least the CD may be produced by your lordship.
My lord,
Next
Okay,
week.
let's have it next week. then.
Next week, lordship.
You can wait for next week.
Next week.
Yes.
My lord,
Immediate, lordship, next week.
page 14, my lord, your lordship kindly see. My
You
lord, I am reading one
have
line.
waited for 1 week. You can wait for 1 week.
My lord, one line, your lordship kindly see, my lord.
Wednesday. Yes.
Wednesday. Right, lordship.
My lord, my protection is very necessary, my lord. My lord, I am humbly praying, my lord.
18,
for your
lordship.
lordship.
19, lordship.
Holidays, police are busy. Independence Day, everything. They will not go for you.
Obliged, my lord.
Yes.
Highly obliged. Obliged.
Please, your lordship. The engaged counsel is in another court. Most respectfully request for a passover for the time being in this matter.
Item 11.
I'm sorry, my lord. My lord, the FIR your lordship will find, my lord, at page 12, my lord. Starts from page 12. Contents is page 15.
35(3) notices were issued to them.
35(3) notice was issued. We appeared before the IO also, my lord. And my lord, the alleged victim, my lord, there was some altercation between the petitioner and victim, my lord, due to some miscommunication. And that was resolved between the parties, my lord, and that was submitted before the IO, my lord. The opposed Mimanka is at page 23, my lord. This amicable settlement, my lord. And they admit, my lord, there was some miscommunication, my lord, and they have resolved among themselves. In persons to the notice, my lord, I appeared, my lord, my statements are also recorded. And this alleged victim did not lodge the FIR, my lord.
So if you appeared and nothing happened, then why are you here?
But since they filed an anticipatory bail, that was rejected.
Page 24 Lordship.
Page 24. Lord.
They have filed one anticipatory bail for the court below Lordship. It was rejected.
It was rejected, Lord. It was before that, Lord, filed before the statements were recorded, Lord. Now, Lord, because of that, my Lord, I apprehend because since there is a rejection.
After perusal of the CD, it was rejected, so we'll have to peruse the CD.
Lordship will grant me an interim, my Lord, protection,
No.
my Lord, in fact. Otherwise, my Lord, if your Lordship find page 23 for a moment, my Lord. Page 23.
Yes, what is there?
Page 23 is by the victim, my Lord. The victim did not lodge any FIR, my Lord. A victim submitted this amicable settlement note before the IO, my Lord, on the next day itself. Victim said, my Lord, there was a miscommunication between them, and they among themselves have resolved it, and they have nothing against each other. A young boys, my Lord, some
Already settled or what?
Yes, that
page 23.
that settlement agreement is there, Lordship.
Page 23.
Apprehension is not there, if we can see, Lordship, because 35(3) notices are already given, and they have stated that they have also appeared.
I'm being Lordship will protect me, my Lord.
Learned counsel for the petitioner and PP. An application under so and so. Petition against the petitioners is that they wrongfully restrained the persons named in the FIR and humiliated them by asking them to lower their trousers, determine their religious identity. The CD submitted that the matter has been compromised. This regard, the alleged victim has also submitted written note to the IO. Furthermore, pursuant to notices given under section 35(3) BNS had appeared the IO. Accordingly, it is provided 20,000. Again, not it.
Highly grateful. Obliged.
There, please, Your Lordship. It's a case of NI Act, Your Lordship. So far, my instruction is concerned, the petitioner is at Delhi because for his treatment. Because of that, negotiation could not be placed. He want to negotiate this case with the other side, Your Lordship. So sometime may be granted, and if it is not happened, then Your Lordship may hardly.
Lordship, this is a negotiation. Simply, he is to tell earlier also against him. Same respondent has filed complaint. Another 6 cases is going on. Out of that, in two cases in appeal, we got the order in our favor. And another 4 is going in the trial court. There is no scope of this negotiation.
There is no stay, is there?
There is no stay.
No scope for it.
And just I need some time just to come back from the.
Lordship, this is, I'm filing today this objection, affidavit in the opposition, and I'm giving the service copy to him also.
Today, learned counsel for the petitioner, learned addition counsel for respondent submits that an affidavit has been filed today. Is the matter again on so and so along with the said affidavit filed by the respondent. Petitioner may conduct negotiations with the respondent if so advised.
26. 27, can you?
26
27, can you?
August. No,
Yes, yes.
after that, 26 2nd September. Published.
Right.
Lordship, my lord, my senior is pass over for something. May I please your lordship? Lordship, it is a part hard matter. Earlier it was Honorable Justice.
Ordered. All right. Raise the matter before the appropriate bench.
If interim order passed earlier, may be continued.
Interim order passed earlier to continue till the next date of listing list on date.
Obliged. May I please, Your Lordship. This is a revision against conviction. Well, conviction under section 341 and 326/34. Under section 341, my lord, for 15 days, and under section 326, my lord, for 4 years. Both brothers, my lord. The appellate court judgment is of 22/8/2022. And they have surrendered, my lord, on 9/7/2025. Already, my lord, 392 days they are in custody. 1 year is past, my lord. They are in custody. They are in judicial custody. In the main revision petition, my lord, the order passed by the learned CJM is at page 19, my lord. The operative portion, page 31, my lord. There are lots of contradictions, my lord, that has been proved by the IO regarding the commission of the offense. Page 31, my lord.
So the judgment has been stayed.
No.
Execution of sentence. IA has been preferred.
IA has been preferred.
Order, any order passed? No.
No. IA is pending, my lord.
So you are in jail now.
I am in jail. Both the brothers, they are in jail. My respectful submission, my lord, the matter may be admitted and they may be allowed to go on bail, my lord. Already 1 year has passed. 4 years. Conviction of 4 years, my lord, 1 year has already passed. 13 months passed. Both brothers, my lord.
There may be some contradiction here, some contradiction there. That is a
Contradictions regarding the occurrence, my lord, and the medical evidence not fully corroborated, fully supported the prosecution version. That is there, my lord.
Observation of the court below, Lordship, is that there are minor discrepancies.
Discrepancies are there.
minor.
And the medical witness, my lord, medical evidence PW 5.
already 13 months, my lord, there in custody, my lord. If lordship comes to the
What is the injury?
lordship, if come to the PW5, my lord, the TCR is there, my lord.
That lordship will find that inner page 22 lordship. Inner page of the judgment 22 lordship.
Yes.
Paragraph number 33 lordship.
Good progress.
On injuries on left side of the face cheek, on the right side of the face cheek, lateral aspect of the right knee caused by sharp weapons, which were fleshed, and third injury was simple in nature. As per PW8, he advised PW2 for X-ray, mandible of EP and lateral view on X-ray pictures.
But X-ray was done after 1 week, my lord. That part is there. Immediately they were not under police requisition. They were admitted in hospital. For some days he was there in hospital, my lord. But the accused persons, they were there.
Just
That is
one
not
fracture is there, I think. Just one fracture is there, I think.
true. That is not as per the
prima facie appears to be a little excessive. Of course, we have not seen the whole facts and circumstances. We'll just I think we'll pass order on the IA for now. Pass the order. We'll pass orders on the IA.
Plus, the revision is admitted. Lord. Deeply obliged.
I need to dispose of revision to data.
May I please your lordship, my lord? I move by this application, my lord. The petitioner, my lord, prays for cancellation of bail earlier allowed. The petitioner, my lord, hearing is the my lord father of the child who has been gang raped, and my lord, it's a my lord such a mental trauma that my lord subsequently my lord child feels pain. Accordingly, later my lord she gets to an angel child, my lord. Now, my lord, what happened, my lord? The bail granted to the accused person, my lord, by the learned session special judge, Pokuraja, my lord. And while allowing the bail, my lord, there is a specific condition that there shall not be no threat, inducement of any kind, my lord. Now, my lord, after passing of this order, my lord, bail order, the accused person, after releasing on bail, they, my lord, tried to force the father of the guardian of the child.
No, what is the position now? It is listed for admission, but as per previous order, there is some, I think, non-service of notice as yet on respondents.
Appeared, my lord.
Appeared.
My lord, next kindly for a moment, my lord, annexure, my lord.
PCR not received.
Lordship, this
PCR also received.
Received, my lord.
Yes.
in the POCSO case, the trial is going on, but in the complaint which they have filed, the FIR, whether that is under investigation or not.
My lord, that is under investigation. My lord, kindly for a moment, page, my lord, 31, my lord, type copy.
No, what is this revision for?
My lord, cancellation of bail, my lord.
Cancellation of bail.
Because of my lord, annexure, my lord.
Revision for cancellation of bail.
Yes. Under 483, my lord, subsection 3, my lord.
A criminal petition.
Criminal petition, my lord.
Under
483, my lord.
528.
Petition under 528, and the provision is under, my lord, section 483 of 3 for cancellation of bail, my lord.
Is that not a separate application? It is listed separately. Bail cancel is a bail cancellation application.
There is a bail cancellation column, Lordship, yes.
Yes, there is a column.
Otherwise, my lord,
Because you mentioned 528 in the cost title, it was listed as a criminal petition.
Bail
Should be a bail application petition. Bail cancellation petition. Yeah, amend the cost title.
My lord.
Post title lordship correction also will not do because it has already been registered as criminal petition. It has to be registered under 483. So that will be bail cancellation again. The whole application will have to be.
What do you think? We are not here to give you legal advice, so you
I will see my lord.
what to do. On the prayer of learned counsel, list the matter again on so and so. Mr. So and so enters appearance on behalf of the respondent number 2 and 3. Yes.
Autumn.
Please, your lordship. So this is a case of NPPS Act, lordship. Petitioner is in the bar 324 days, lordship.
Commercial.
Commercial quantity, lordship. He was detained on 22 of September 2025, lordship.
Yes, what is your ground for seeking bail?
Lordship.
What is your ground?
Lordship, ground is that, lordship, he was detained on 22/9/2025 from the LGIBI airport, Gauhati, and was produced to court, lordship, on 24th of September 2025 of 5:30 PM, lordship. The violation of Article 22 and also
Where is the detention? Where from do you get that?
lordship, page number 12, lordship. Next part is to case number 13, point number 3, lordship. This is the petition which is filed by the custom in the Honorable CJM court, lordship. They describe here that 1:30 hours of 23/9/2025 in presence of two pansas, the custom officer requests the passenger Shri Hemanto Borlo to open the briefcase on their custody, lordship.
You were produced on 24th.
24th, at around 5:30 PM.
Where is that?
That is not their lordship, that is. Yeah. First page, Lordship.
Is first page, that is after transfer of the case record, is it not?
Well, Lordship, the petition also filed. The petition at page 11, Lordship. What is, and also page number 22, Lordship, the order by the Honorable CJM, Lordship.
Page
22, Lordship. Of my. It was sold at 24/9/2025. Lordship.
So what is your time of arrest actually?
They said that I was formally arrested on 23/9/2025 at 9:30 hours.
Morning.
Morning, Lordship.
4:30.
Hmm?
He was
sorry.
detained on 23/9/2024/26 in the International Airport at 1:30 p.m. 1:30 a.m. Then formally arrested on same day on 23/9/2026 at 4:30 p.m.
But
That is formally arrested, but he was effectively in detention from 1:30.
1:30, Lordship. Not 1:30, that 11, Lordship. 1:30 hours before, Lordship. Because the flight arrived at 11. They also the FIRs also see that the case registered on 22/9/2025, Lordship. Department, they themselves give that the case was 9/2025. Clearly violation of the Article 20.
Yes, Mr. Kyle.
Lordship, I first come to page 13, paragraph 3.
Yes.
That sir, approximately at 1:30 hours on 23/9/25 in presence of the Panchas, the custom officers requested the passenger Sri Hemant Bardule to open its checked in bag and hand bag for examination. The said passenger was carrying two check-in luggage, one olive green colored trolley to one hand.
Yes, I have already read this part. Yes, what do you want to submit?
Lordship, now Lordship, section 42D. 42D of NDPS Act. Lordship.
Yes, 42.
D.
Yes.
Detain and search, and if his things proper, arrest any person whom he has reason to believe to have committed any offense punishable under this act. Is correct, Lordship, on 23/9/2026. He was detained, but formally arrested after such and seizure after completing of the formalities. When they think that the person is required to be arrested, then he was formally arrested on 4:30 p.m. of 23/9/25. It knows that this is a special act, Lordship, so before arresting, necessary formalities to be completed, Lordship. My in written submission, Lordship, I have
All right, detain and search. So if he is detained, that means before conducting the search, you have detained him.
Lordship, there is a difference between a formal arrest and detention.
Yes.
That's why, Lordship, after completing formalities,
The difference is the formality of it.
completing the formality, formally he was arrested at 4:30 p.m. on same day.
Yes.
Within the prescribed period, he was.
So according to Niranjan Singh, what should be regarded as the time?
Lordship, here, before Lordship, I have given my written submission before your Lordship. Lordship, please to see page 1.
This one.
Is provided under section 42 NDPS Act, power of entry, search, seizure, and arrest without warrant under section 42D. The act provides for detained and search, and if he thinks proper, arrest any persons whom he has reason to believe to have committed any offence or punishable under this act. The aforesaid provision stipulates that a person may be detained for the purpose of investigation on the reasonable ground of suspect, and after conducting proper search and seizure, he may be arrested. Subsequently, when officer who made the arrest is satisfied that the person has committed an offence under NDPS. And here in this case, the accused was detained in Gauhati International Airport around 1:30 a.m. on 23/9/25 and brought to the custom office for the purpose and search and seizure, preparation of inventory and panchnamas and testing formalities, and was formally arrested on 23/9/25 at around 4:30 p.m. under the provision of 42 NDPS Act and reasonable belief that he has violated the provisions of NDPS Act. Immediately thereafter, the ground of arrest under section 47 and 48 of it served to the relative of the accused persons wherein it was duly handed over to the petitioner. Thereafter, the accused persons were produced within the stipulated period of 24 hours before the land at CGM, Kamrup, Gauhati at Gauhati. In view of the same, it is respectfully submitted that although the petitioner was detained on reasonable suspicion under section 42 of NDPS Act, he was formally arrested at 4:30 p.m. on 23 and 25 after observing all the formalities, and he was produced before the land at CGM within 24 hours of his arrest, and as such there is no violation of Article 22(2) of the Constitution of India and other laws holding the field in this regard. This is our explanation.
You are referring to some judgment, Odisha High Court.
Yes, Lordship, I have annexed one judgment of Bombay High Court. Lordship, initially Honorable Supreme Court.
Lordship, Honorable Supreme Court, the file judgment is stated clearly, Lordship. Niranjan Singh, Lordship, lastly Subhash Sharma, Lordship. But this is also a case of special act, Lordship, PML Act, Lordship.
We have annexed.
Already you have annexed the judgments. But Supreme Court in that case has only issued notice.
Lordship, thereafter finally it was disposed of.
Right?
Lordship, by order dated, the last order, page 17. No, Lordship, probably this is already disposed of.
Pending, Lordship.
No, Lordship, it disposed of.
No judgment till that Article 22(2) is relaxation in any act, Lordship.
Finally it was disposed of. No interference was made by the Honorable Supreme Court as directed earlier.
Nothing was decided, it is just a notice.
Nothing is decided. Meaning thereby the Bombay High Court judgment is holding the field.
No. Mr. Sibal would point out that various high courts have held that a person is taken to be arrested from the moment his liberty is curtailed. And formal time of arrest shown by is immaterial. It is pointed out larger issue is a pending consideration in Pranab Gupta. Council referred to following judgments of Punjab, Mumbai and so. Issue notice. What is availed, what is not availed?
Was Lordship disposed of, I have given one page order of Supreme Court, where Lordship not interference was made with the judgment of the Honorable Bombay High Court. Only court director was given to the petitioner to approach the Bombay High Court, seeking a regular bail. This point was not decided.
So the Niranjan Singh will hold the field if it is not decided.
Lordship, in my humble submission, because under section 42(2), 42D, Lordship, the power is given to the authority. So after completing of the formalities, he was formally arrested and within a reasonable
The
time.
power may be so, but if since the Supreme Court has interpreted the meaning of the word arrest
Lordship, here, Lordship,
in
is to be
Niranjan
section
Singh.
42(2) also, into taken into consideration. Because in all these. judgments, Lordship,
You may make a fine distinction, but for the purpose, question is for the purpose of Article 22, what is to be regarded as arrest?
Correct, Lordship. Lordship is very correct, but my submission, Lordship, so this is also, I am making my submission on after reading section 42 to 42D also. Because all the judgments I have gone through, Lordship, all these are judgments are relating to, not to NDPS Act laws. There is no provision in the PMLA Act also to that effect, Lordship. What is been stated in 42D also. Of course, in case of one judgment passed by Odisha High Court, this point was taken into consideration.
Was detained, Lordship, on 22, Lordship. Before 12, from 11 AM, Lordship. One whole day, Lordship, day.
That is
Took him in
incorrect,
their
Lordship. This
custody.
is an incorrect, Lordship. You are pleased to see.
Go ahead.
Paragraph 1 of page 12, Lordship.
It counts from 1:30 AM hours, then also did. Beyond 24 hours, Lordship.
Because the
24 whole day, Lordship.
439,
Lordship,
439 CRPC, whereunder we exercise the power to release, the word custody is used, not arrest or detain. It says custody. And in Niranjan Singh, Supreme Court has explained the meaning of the word custody.
Lordship, correct. I'm not submitting it to the contrary to the Honorable Supreme Court judgment, but that was relating to some other act, Lordship. Because there is a specific provision in NDPS Act regarding search and seizure and arrest. Then Lordship.
Even if it is under NDPS Act, we will be exercising powers only under 439.
Yes, Lordship, but section 42, we cannot ignore section 42.
We cannot ignore, but there is no question of ignoring. But what is stated in 439 is person accused of an offense and in custody. So since when has he been in custody? That is the only question.
Yes,
whether he is detained, whether he is arrested.
Lordship,
That 42 mentions two words. One is detain, one is arrest.
Yes, Lordship.
Yes. So detain, arrest, both are custody.
No, Lordship, here Lordship is to see whether reasonable belief is to be taken into consideration in case of NDPS. Reasonable belief. Reason to believe. When it is come to the.
Yes, if he has reason to believe, if he has just, I think the word used is, if he thinks proper.
The detain and search, section D, I'm again reading it.
Detain and search, and if he thinks proper. Yes.
Arrest 20%.
So after he thinks it is proper, he will make a formal arrest. But before that, he has to detain.
Not correct. Lordship, he has to, from which time he has to be, 24 is to be counted.
That is what Niranjan Singh says, the word custody means effective detention.
But it was relating to a PMLA. If that provision is not there in the.
No, even if it is under PMLA Act, we are exercising powers under 439 and Supreme Court has explained not PMLA Act but 439.
There is a special provision in NDPS Act.
Yes.
You can ignore it.
Yes, sir. So 439 is applicable to NDPS Act also.
No, it is applicable, but Lordship, the word.
Fundamental rights, Lordship, how can I?
Mr. Council, please. You submit, I will submit to it. Lordship, here Lordship to consider section 42D. I'm again reading for benefit of me, Lordship. Detain and search, comma. Then if he think proper, comma, arrest any person whom he has reason to believe. Then he has to come to a reason to believe. Then he can put the person under arrest. There is a difference of time, Lordship, from detention and formal arrest.
But the effect of Niranjan Singh is that from the time of detention, it has to be counted.
Correct, Lordship. I am not disputing.
Then
that,
if it is correct, then we have to take the time of detention.
But that is relating to another act, Lordship. But there is a special provision in the NDPS Act, Lordship.
All right, I think we have followed your submissions, whether we.
Lordship, my submission may be considered and cannot dictate a Lordship to pass each other. Yes, sir.
Now that we'll examine in a little detail, so we'll keep it for some time.
In my submission, Lordship, I have referred to support judgment. So although copy has not been given, but I have mandatory compliance with the provision of NDPS Act concerning arrest, search and seizure, especially under section 42 is essential to protect the innocent person from undue harassment. The mandate of the
You
honorable.
submit the judgments.
Yes.
Yeah.
Much. All right.
Made, please, your lordship. Lordship, on last occasion, notice was issued.
Time na ho.
Due to some difficulty, your lordship, on last occasion, we could not take steps. Kindly 1 week time may be granted to take steps, your lordship.
Just prayed for by learned counsel for the petitioner one next time. Granted to take steps. List again on.
Keep your lordship.
Lordship, in this case, the TCR was already received. Lordship had called for updated TCR if any witnesses had been examined. Was element.
Harvey's report is also not complete, man.
Harvey's report.
I'm sorry, man, it's not a case of POXO, man.
What is this?
Lordship, 64 allegations are there. Alleged that there was cheating on part of the accused petitioner, but all of those facts have not been substantiated on behalf of the.
On a key statement, man, she has implicated.
All those things will need to be substantiated during the trial, Lordship, as well. And he's already in 85 days of detention. Charge sheet has been submitted, trial has started. Further 12 witnesses are there, Lordship.
On 18/7, my lord, the victim was not examined, my lord. No PW examined, my lord. 18/7, the case was fixed, my lord. On that day, my lord, no PW stand up on that day.
Victim has to be examined, I think. Because
Lordship, there is no violence in the case, and
there is no violence, but there is misrepresentation and cheating.
those aspects have to be established during.
Yes, prima facie for our satisfaction, we see these things. What was the last date?
18/7, man.
18/7. Next date is available.
It is not, my lord.
Huh?
It is not clear from the, my lord. The status report may be there, my lord. But
I can confirm and let the court know.
Yes, confirm and let them know. If it is next date is there, we can fix it on that date.
Apply.
After that. Part learned counsel for the petition. PP. Said that the victim is yet to be examined. The position of the victim is yet to be recorded as the last date did not appear. That the next date fixed is so gap rakhi dibo pisot inform kori dibo. Is the matter again on call for an updated
It will be in the month of September.
call for a status report inclusive of the deposition of the victim if recorded. If the date is date should be before that, I think it is
If
POCSO
if
matter.
it's earlier than that, then accordingly adjust.
Yes, date to sile hoi pele delay hobo. Next date to ani dibo.
Apply.
Petitioner is behind the bar for 48 days as of today. So FIR is at page 10. Lordship.
Yes, madam, we have not received the case there, madam, and IO has paid for some time.
But earlier 2 occasion bail case diary was called for, and person is behind the bar.
That is what happens when you get the matter fixed on 14th August.
CP,
CD does not come. That is what happens when you insist.
your lordship grant more time, the same thing will happen.
Next week, madam. 21 of.
All right.
19 lordship.
19. Yes, CD not IO has Lionel additional PP submits that IO has prayed for some time to produce the CD, accordingly list the matter on it.
Legal lots. Regular bail application, madam. Offense is under NDPS Act, madam, under section 21B, 22C, read with 25 and 29. Case diary not received. FIR is at page 11. Petitioners are behind 85 days already, madam. In custody, and no recovery was, they are not named in the FIR, as well as their no recovery was made from them. They were arraigned as subsequently on the basis of statement of the co-accused, my lord, who were already arrested, my lord. FIR is page 11, my lord. On the material, my lord, that connecting them with the present case, well, except the statement of the co-accused, my lord.
We don't know. That is why we have to see the CD.
That's for the grounds
It is
of
commercial quantity, is it not?
Yes, but it is recovered from some other person's house, my lord.
Whatever.
I was also, petitioners were also not present also at that time, my lord.
If the prosecution concedes that is the case, that nothing was recovered from you and only material against you is statement of co-accused. If prosecution concedes to that, then we can.
FIR itself disclosed that they were named, they are also not named.
No, subsequent to that, there may have been development.
Development, I mean, the
Further
ground of arrest
investigation
was
may have revealed independent material against you.
It's 24, my ground of arrest. It is mentioned that only
No,
omnibus
that was
statement.
ground of arrest, but further investigation may have revealed something else.
And in view of the Honorable Appeals Court judgments, my lord, knows, my lord, into punching judgment on the basis of co-accused statement, my lord.
That is what we have to ascertain, whether it is only co-accused statement or there is something else has surfaced during interrogation, course of investigation. It says accused may lead the police to other locations where contraband is kept hidden.
Already 85 days, my lord, that they have sufficient time to interrogate.
So that is what he may have led and found something that we can see only from the CD. Maybe the charge sheet has also been submitted, who knows?
Allegation only against them in the ground that they have to purchase from the arrested person.
Yes, when?
24, madam, 24/8.
That will cross 90 days.
180 days of business.
180 day
180
offense.
days in
Okay.
commercial. Much of it. 24.
Lordship, for 26, next date is today itself.
Today.
Dates. So, last week of August, Lordship.
All right. Give.
24, 20.
May I please, your lordship? Lordship, this is a regular bail application. Lordship will find the FIR at page number 12. Lordship, the contents of the FIR reveals that there has been some illegal extortion activities being carried out by some alpha cadres. Lordship, further at the last part of the FIR Lordship will see that there has been an active network of some linkmen who helps these alpha cadres in carrying out these extortion activities. So based on this FIR, the present accused person was arrested. Lordship, my humble submission is this, Lordship, that I am innocent. There has been some financial transaction between me and a person named Parthojit Kaur, who has been also been shown as a alpha cadre. Lordship, there has been some telephonic conversation between me and some alpha cadres. Lordship, what I'm submitting is this, Lordship, that during my custodial interrogation, Lordship, I have cooperated with the investigating agencies, and Lordship, I have told them specifically that this person, Mr. Parthojit Kaur, I know him since my childhood, and it was I never knew that they are involved in Alpha. They are cadres, active cadres of Alpha. So, Lordship, I have already cooperated with the investigating agencies, and Lordship, further I will cooperate. Lordship, whatever conditions that may be imposed by this honorable court, I will abide by this. Lordship, I humbly pray that further custodial detention may not be required, Lordship. I'm behind the bars for more than 52 days, Lordship.
There appears to be plenty of material against you.
Lordship, I am not denying that there was financial transaction, Lordship. And Lordship, whatever I knew, I have already informed the investigating agency. Now the question arises that whether my further custodial detention will be required. I'm cooperating, Lordship. Further, I will cooperate. And I'm saying, Lordship, that at the same time, I'm saying, Lordship, I'm innocent because I never knew that they were alpha cadres. My only mistake was this, Lordship, that I trusted my childhood friend, and whatever he said of transaction, I did those transactions, Lordship. I was at that point of time, I did not knew that he was an alpha cadre. Lordship, I belong to a respectable family, good family from Dhemaji town. I stay there permanently. So, Lordship, I humbly pray that any condition may be imposed. I will abide by that. And for in future also, I have participated in the investigating process. I have cooperated. In future also, I will cooperate, Lordship. Perhaps the CB will reveal that I have cooperated, Lordship.
UAP Act is there. 1013. UAP provisions are also there.
No, Lord.
See, provisions are there, my lord, but what I asked my lord, learned friend, that he stated that directly this bail application is filed here. Otherwise, my lord, that is the provisions of NI Act will come, my lord, as per that schedule. If it is, my lord, rejected there, only, my lord, appeal lies, my lord.
No, it is not NI investigated.
But, my lord, the schedule is, my lord, under the NI Act, my lord. When
Some
the
police is
UAP,
investigating,
my lord, sections are there. Because, my lord, that is schedule, my lord, the my lord stated that, my lord, the Unlawful Activities Prevention Act under, my lord, it is the NIA code only, my lord, take up. And as per notifications, my lord, the learned session just, my lord, act as a NIA,
1013,
my
sir.
lord. Here, the remand order from, my lord, the JMFC, my lord. When, my lord, it is, my lord, produced, my lord, within 20.
Very good. Investigation agency. You are referring to 21.
Yes, my lord.
So against an order of the special court, it will come.
Yes,
in
my lord.
appeal.
My lord, now, my lord, learned friend stated that directly, my lord, filed before this, my lord. No, my lord, petition is pending, my lord, there, my lord. As he stated, my lord, because it is not annexed, my lord. May not be, my lord, applicable, my lord, because if it is directly come, my lord. If, my
Yes.
lord, it is rejected, then only, my lord, appeal, my lord. Then, my lord, the division bench, my lord.
The case is not pending before a scheduled court, is it?
Yes.
Before a special court?
My lord.
Huh?
My lord, because it restricts court, NI court is not there. Covered.
No, NIA court has jurisdiction all over the state.
There may not be NI.
No, the NIA court in Gauhati, that has jurisdiction over the entire state of Assam. If it is an NIA investigated offense, then it will be before that NIA court only, not in the district where it is conducted. This will require some examination because of the
Yes, ma'am. It is, my lord, from, my lord, Dhemaji, my lord. Otherwise, my lord, in the NI Act, my lord, section 10, my lord. Section 10, my lord, the power of the state government to investigate schedule offences, my lord. Here, my lord, as because it is a Assam police, my lord, investigated the matter, my lord. So it is a Dhemaji PS case number, where, my lord, the UAPA sections are there, my lord. So as per the provisions of section 10, my lord, these cases, my lord, investigated by, my lord, that is the, my lord, the Assam police, my lord. My lord, what my respectful submission before your lordship is that when, my lord, the UAPA section is there, my lord, when the matter is tried by the learned session judge, my lord, at that point of time, as because, my lord, under the, my lord, NI Act, my lord, as per the schedule, my lord, UAPA is there, my lord, then the learned session judge, my lord, act as a, my lord, NI Act, my lord. That is my lord, submission, my lord. But here only, my lord, the question arises whether, my lord, any, my lord, bail application before filing this is pending there or not, my lord. As per my learned friend's, my lord, submission, my lord, he has no such instruction, and this is the phrase bill, my lord, that is, my lord. Here it is. Also 20.
Is there any notification designating the all sessions court as
Yes, there is a
My lord.
notification is there? So, thing is that if it is investigated by the state police and
My
it is a scheduled offense, then it can be
My lord.
at the court of sessions
My-
where
my-
the occurrence takes
my-
place. Because it is designated
my
as
lord.
a
My- my-
special court for the
my-
purpose of
my-
this.
my-
But if it is investigated by the NIA, it will be at the NIA, in the
my
NIA
lord, my
court.
lord.
And in that case only section 21 will apply. If it is,
My lord, 21, my lord, what my understanding, my lord, that is that, my lord, in my lord, that notwithstanding anything contained in the code, an appeal shall lie from a judgment, sentence, or order not being an interlocutory order of a special court to high court, both on the facts on law, my lord. The word is, my lord, that is the special court, my lord. Special. So when, my lord, it is, my lord, tried by the, my lord, learned session judge as a, my lord, this special court, my lord, then that is applicable in that case also.
I think there is some judgment on this point also.
Yes, my lord. Code
Whether-
has, my lord, some judgment, my lord, of our high court also, my lord. Two, my lord, two, my lord. that is
Regarding the power to entertain directly,
stated, my lord, if it is,
439 power is intact.
my lord, where, my lord, if it is rejected, my lord, there, my lord, any order, then, my lord.
Then of course it will be,
DB, my lord.
no doubt about that. But whether in the, in view of section 21, he can
My lord.
approach directly
My lord.
without approaching
Yes.
that court first. So in that respect also, I think there is judgment saying that it can be.
Otherwise, my lord,
Because
in this case,
that
my-
court will also be exercising power under 439.
My-
So these are coordinate
my lord, my-
powers, concurrent powers. So we can proceed on merit. All right, we'll examine. What? Yes.
D8.
Is anything else to submit? All right.
I'm obliged, Lord.
May I have the lordship? Lordship, this is second bail application, lordship.
No, like, did you? Yes.
I tell you what, 30 my lord, although
Second bail application.
the scan copy was called from my lord. I have verified from the record. Only the order sheet has been forwarded, my lord. Other my lord, the part of the case that it is not in the scan copy of the record. It's POCSO case, my lord.
So three witnesses have been examined, lordship, already.
Hmm?
3 witnesses have been examined by the London trial court.
It must have been sent before the examination. Last order is of 3/126. Whereas it was sent on 10th of August. This is complete.
Service is not also not complete.
Huh?
Lordship petitioner is behind the bar, Lordship, since today, as on today, 287 days, Lordship.
Seems notice was not issued to the. This is POXO, isn't it?
Also, it's 13 years old.
This was not issued. Learned counsel for the petitioner. And copy of TCR has been received, which is not accompanied by the evidence at the depositions of the witnesses, three of whom have been examined as submitted by learned, three examined
Re-examine.
by learned counsel for the petitioner.
Team and her parents.
The last order available in the TCR is of P126. Although the same has been communicated under order dated 10/8/2026. The subsequent orders passed by the learned trial court not available in the order sheet. The learned trial court is directed to send up-to-date copy of the record, including the case diary and the depositions of witnesses recorded so far. I think you have not taken steps for notice. Issue notice on respondent number 2.
Waited.
List again on.
Much obliged.
Fifty-three.
Please, Lordship, regular bail application, Lordship. Initially, the case was registered under section 87. Later on, added section 4 of POCSO, Lordship. Lordship, today is 85 days behind the bar. The victim willfully eloped with the petitioner, Lordship. There was a law of affairs. I consider length of detention, Lordship.
Is he received?
He received it.
Did he? Victim is aged 17 years. And she says from last 8 years. So from the age of 9, she is in love with the accused. Yes. The heard learned counsel for the petitioner is an application under so and so the allegation as reflected in the FIR. Is that the petitioner kidnapped the daughter, 17-year-old daughter of the informant from the road in front of her house. So, where learned counsel for the petitioner submits that the petitioner and the victim were in a love relationship, and considering the period of detention of 85 days,
85 days.
therefore bail may be allowed. Where the CD as called for has been received from the statement of the victim, aged about 17 years. It appears that she had eloped with the petitioner. So, having regard to the above as well as the period of detention, the prayer for bail is allowed. 20,000 to sureties.
Special box, so good, I mean, the special box. Kamru, I mean. Acha.
4 to 57.
Take up my item number 57 first, my lord.
It was only 30 when I Yes.
But in 57, Malad, page 10 is the affair, Malad. Lordship might remember, Malad.
Item 57.
57, Malad. Malad friend is Malad. Take 57 plus 57, Malad. But page 10 is the affair, Malad. Lordship has dealt with the matter, Malad, that Abdul Mintu, Malad, and then Malad. In this case, Malad, he was earlier, Malad, granted interim pre-arrest bail, Malad. Then, when he went to the police station, Malad, he was arrested in other cases, Malad. In this case, Malad, he was under interim protection, Malad, initially. Then he went to the police station, he was arrested in other cases, Malad. Then when the matter came up for hearing, I apprised the court, Malad, that he was arrested in this case, Malad. Your allegation is against Abdul Mintu Ali, that Malad. He assaulted one person, Malad, and Malad, one person got injured in the eye, Malad. So, Malad, my humble submission is that it's a totally false allegation that there was an injury, it was not a gunshot or like that, it was a scuffle. Lordship may kindly see whether it was a gunshot. We have received the case diary, my lord. When the victim person, he was also arrested, my lord. Yes, the victim was, my lord, it is a gunshot, my lord, and victim was operated in Health City Hospital, Guwahati. Victim was operated in Health City Hospital, Guwahati, my lord. Then, my lord, the part of the bullet, that was, my lord, operated from the left eye, my lord. And my lord, final injury report is yet to receive, my lord. But doctor has given, my lord, that is a document, that it is so kind of certificate, my lord. And that part of the bullet that has been seized by the police. There are sufficient incriminating materials, my lord. So I strongly object, my lord, because it is a vital part of the body, my lord, and somehow, my lord, he is safe, my lord. Even, my lord, the victim, my lord, he has given, my lord, statement before the IO, my lord, and there are also eyewitnesses who is also implicated, my lord.
This is 57 is
A number 2279, my lord.
yes, and what is the other bill application for Abdul Minto? This item 56.
Then lordship may take up, my lord, item number 54 and 55, my lord.
That is also Abdul Minto.
Yes, my lord. Abdul Minto, my lord. In this, my lord,
54 and 56.
lordship, my lord, take up 54 and 56. 54, no, 55. My lord, Rohan Ali and Abdul Minto, my lord.
Yes, what is this?
Rohan Ali and my lord, Abdul Minto, this is 55 and 56, my lord. So in this case, my lord, what happened? This Abdul Minto, my lord, he obstructed, my lord, the brother of the informant, my lord. And he was asked to, my lord, withdraw this police station case, my lord. Wherein, my lord, his brother was shot, my lord. And he was also threatened, my lord, that if you not withdraw the case, my lord, he will also be shot like his brother, my lord. And injury report also collected, my lord, and there are 183 statements, my lord, of the team. That I'll place it, my lord. Thank you. Right, by 56. 54 to 1939 and 54 and 55, sorry.
So these are all victims.
They're all victims, my lord. But this is connected to, this case is connected to other case, my lord, wherein his brother was shot, my lord. Because in this case, my lord, they were threatened to withdraw the case, my lord. If they have not threatened, my lord, if they have not withdraw the case, they'll be threatened to, my lord, shot by this accused person, my lord. And there are also, my lord, allegation of physical assault, my lord. That in fact, my lord, the one that they have implicated.
In this cases, there are no injury, there is actually, we got interim, we appeared in the police station, we are arrested in this case. And moreover, Abdul Minto, his wife is suffering from cancer, two minor children are there, in advanced stage, of carcinoma, Lordship has granted bail to her also, in previously, but in the other cases, all afterthought, because it's a long family between two families, there's a long dispute since 2018. Since 2018 is a long dispute,
But you hand over the CD.
We have also lost the case against them, and that also case has been registered, and in the police report, Lordship will get, that there is a long pending, dispute between both the families since 2018, and they were also, some of them are absconding, There's a police report, Babullah. So, and moreover, considering my wife's illness, and considering two, nobody was there, and Lordship, the wife, she is suffering from cancer, and I am in detention, as of date for 43 days,
So, my lord, what has happened, my lord. Nothing, if there is something happened, what has happened and nothing more to happen, my lord. Considering the length of detention, my lord, and my lord, considering the fact of my wife's illness, my lord, and other factors, my lord, you may kindly grant bail, my lord, because apart from two minor children, then nobody is there, my lord, to look after her. This is advice for better treatment. Obliged, my lord.
One more item left, my lord. The item number 56, my lord.
56, what is 56?
It's my lord, bail application number 2127, my lord.
What happened there?
In this case, my lord, the informant is different, my lord.
But from the same family member, my lord.
One. Informant one, Resma Begum, my lord. The allegation is that, my lord, her husband was assaulted by the Mintu Ali, my lord. In this case, my lord, I have perused the case diary, my lord. From the case diary, my lord, after the incident, my lord, the police has asked the, my lord, victim and the victim and the other witnesses, my lord, come to the police station to hand over the, my lord, injury report. They have not come, my lord, to hand over.
But there is no injury, my lord, where from they will come.
My lord, that part, my lord, I leave it to your lordship, my lord.
Where from he will come? He is in jail.
No, but not me, my lord.
No,
But victims, my lord.
Victim, my lord.
Victim.
The police called them, as per his submission, police called them, they did not.
I said you call both parties.
No, police called the, my lord,
Victim.
informant and the victim, my lord.
There is no injury in this case, within these cases, my lord. Obliged, my lord.
You are for whom?
Item and 57 lordship for respondent lord.
The respondent for the informant. Respondent won't know.
Anything additional you have to submit?
Habitual offender lordship, poses lordship, weapon like a pistol lordship, and already committed attempt to murder lordship. As a result of which lordship, younger brother of informant lordship, injured lord, got the bullet in this vital part of Iron's lordship. Allegation lordship.
All right, that is already submitted. If you have anything further to submit, then it submit, but otherwise you have to cover what has already been covered.
Desperate in nature lordship, after getting the bail lordship, they are threatening to commit further
All right,
offense
that
lordship.
box is also ticked. Yes.
Objection lordship.
Obliged, my lord.
POXO is there, mother. You have taken step.
Lordship, steps taken, amicus may be appointed, lordship. Notice was also sent, lordship. Otherwise, this year is there, lordship. And 164 is also there.
Granted counsel for the petitioner, PCR has been received. No instructions.
No, lordship, we have not.
Instructions have been received regarding service of notice on respondent number 2. Submits learned additional PP. Having regard to the fact that the petitioner has been in custody since when?
94 days, my lord.
4 days, I deem it appropriate to appoint an amicus to represent the respondent number 2. Accordingly, so and so is appointed as to represent. Extra copy of the petition served upon her. Anybody present in court?
Take, my lord.
An empty person. Just again on. Yes.
Obliged, my lord.
Show the name of just in the next in the cause list.
Lordship, POCSO 6 is there, Lordship. Lordship, on the last occasion, Lordship, CD was called for, Lordship. Notice is required, Lordship, notice not issued, Lordship.
Please.
Yeah, is you taken step?
No.
No,
Lordship,
let him
in
take
the-
step. Oh, Lordship, there was no order regarding.
There was no order, I think. CD not received.
Not received.
CD not received. Appears that notice has not been directed to be issued to the respondent number 2, hence issue notice to the respondent number 2, petitioner to take steps immediately. Place the matter again on.
May I please, your Lordship? Lordship, here the accused is on interim protection, Lordship, and his statements are recorded, Lordship.
Charge sheet has been filed. Notification report, this person has not been named as an accused. In purchase.
Learned counsel for the petitioner, learned standing counsel NF Railway submits that the matter has been charge sheeted, but the present petitioner has not been named as an accused in the said charge sheet. Copy of the charge sheet has been furnished. Keep the same on the record. View of the above, the matter has become infructuous. Dismissed as such.
I think item 58, Lordship, where amicus was appointed, notice was, report was received, Lordship. Only the report is received, Lordship.
All right, notice item
58.
58, as per learned additional PP. Put upon respondent number 2, but none appears.
Your Lordship, the seat was called for and the notice dated for personal appearance.
This case, the personal appearance was directed, madam, so the which is present, madam.
Yes. So what is his reason for not sending the CD for so long?
Submitting, madam, that he has not received the requisition, madam, from our office.
It is for you to explain how come he is not receiving.
That is why, madam. Not, it is, madam, pending since madam, April 2026, madam. Very difficult, madam, how could, madam, they has not received, madam. Whenever we issue requisition, madam, we put the date, madam, on which date and to the police station.
By WT, isn't it? All right, what is there in the CD now?
Case that, madam, this is a cyber fraud, my lord, and this accused person, my lord, is also one of the co-accused, my lord, who is involved, my lord, because the main accused person, my lord, he transferred money, my lord, to this accused person, my lord. My lord. That is why, my lord, police is, my lord, searching him, my lord, and to his mobile phone so that my lord further investigation can be done. Accused person is not, my lord, cooperating with the investigating officer.
Is his name accused?
Ziaur Rahman Lordship.
Ghulam Ali, my lord.
Ghulam Ali Ziaur Rahman Lordship. Petitioner is the Ghulam Ali. He is the mechanic Lordship. The other accused person, the Ziaur Rahman, is transfer money Lordship.
What is the role attributed to Ghulam Ali?
The Lordship of page 5, paragraph 8 Lordship.
Ghulam Ali money transferred to
explained.
his account, my lord. Money, online money.
So he is allowing his account to be used for.
No, that is why under investigation, my lord. They wanted his mobile to be seized for further investigation.
In PhonePe Lordship transfer the Ziaur Rahman to present petitioner Lordship. Present petitioner Lordship, the page 5, paragraph 8 Lordship. I explained Lordship. I am not involved in the case Lordship.
Money is transferred through Binance app, my lord.
Huh?
Binance app.
Binance.
Binance app, my lord.
Finance app.
Binance, BI.
I cooperate with the investigation Lordship, protection Lordship.
You are the mechanic of the garage.
Yes, sir.
Who has transferred the money?
No, there is the main accused person, my lord. His name is Vidul Khan, my lord. He is the main accused person, my lord. And my lord, Dora also, my lord, entered in his account, my lord. There are some account, fictitious account, my lord, and they operated with the permission of that person, my lord. And that person of the who is holder of the account, my lord, they used to pay money to that person, my lord. Dollars were converted to, my lord. And my lord, these are the, my lord, agent, my lord. It was sent to their account, my lord, and thereby, my lord, it was later. So cyber fraud, my lord.
All right, you hand over the CD.
My lord.
In his room.
Developers.
IO has appeared personally and offered submitted his explanation for non-submission of the CD, which is
He is also paid for pardon, man.
that he had not received the requisition. Standard his apology. Which is accepted. The personal appearance of the IO is hereby dispensed with. And go. Yes.
Up to date CD was called for, we have sent message, but due to this Independence Day, maybe they are not able to send Lordship.
Yes, second time.
Message sent on 11/8 Lordship.
Right, next week then.
Lordship.
But up to date CD is not received, list taken on.
21 busy. 21.
I don't know about 34, my lord. There was a wrong submission, my lord. That matter ended in search it, my lord. Actually, my lord, it is not searched, my lord. The investigation is pending, my lord. My lord, may I pay, my lord, that Belchor PS case number 25 of the 26 may be called for, my lord.
Right, it is stated that by learned additional PP that was wrongly submitted, that the charge sheet has been submitted. But the matter is still under investigation. Hence call for the CD. Please take it on.
24. 24. What happened?
Yes, next.
28 August.
Lordship, in this matter, the engaged counsel on legs, so kindly take this matter after some time or at 2 p.m. Lordship.
Next week. Any interim is there?
Yes, Lordship.
Interim to continue. It's done. Will not be able to complete because I am not sitting from.
Madam,
Obliged.
city to be retained, my lord.
Yes, CD be retained then.
Here in this case, petitioner is on interim lordship, and initially he appeared before the investigating officer. He did not record his statement lordship. And as per my instruction, yesterday he was called and his statement was recorded.
He did not receive, my lord. Interim is there, my lord.
But CD did not receive list again on so and so. Interim to continue till next date. Testing.
Obliged, lordship.
And also, my lord, city not received, my lord.
But CD did not receive list again on.
Right, please, your lordship. Lordship, in earlier occasion, instruction was called for.
We receive an instruction, my lord.
Yes, BP.
Yes, my lord, we get a, my lord, instruction, my lord, that, my lord, no criminal case has been registered against the above named persons, my lord. That we get a WT, my lord. That will
Third
be
learned
kept as a part of the
counsel for
record.
the petitioner.
Lord, I have a submission, my lord. A notice has been issued on 11/8/2026. Mohan Chandra Das, Sub-Inspector, Fakirganj Police Station. My lord, this is the copy. Under subsection 3 of section 35 of the BNSS. And thereby directing the petitioner to appear before the concerned police station today, that is on 14th August, 4:30 p.m. I will kindly peruse the notice for appearance. Please,
Fakirganj PS case number, what DBB 59
don't
of
know what is-
26?
What is DBB?
What is DBB?
One police personnel visited my residence and this copy has been served.
Yes, according to WT, it is stated that he visited, you were not found present. So then inquiry is going on, but no case is registered. That is the thing.
Right.
My lord, there is reasonable apprehension, my lord, by this notice. Suppose if I appear today evening, I may be arrested.
There has to be a case diary.
Most probably, my lord, they yet not, my lord, registered the FIR, my lord.
My lord,
They
kindly
not, my lord, they registered the FIR, my lord.
DBB 59/2006 is registered at Fakirganj police stations. What is DBB 59/26 registered at Fakirganj police station?
I don't know. What is DBB? I have never heard it before.
Me too, sir.
Detailed report may be called for, my lord. But what is on,
May be
on
given.
the, my lord, that is the submission of this, my lord. what learned my lord, the friend submitted my lord. On the basis of that, my lord, we will send my
Already heard.
detailed report, my lord.
Learned counsel for the petitioner and learned.
My lord,
counsel in
some protection may be given, my lord.
A WT message from the OC Fakirganj PS has been submitted wherein it is stated that no criminal case has been registered against the present petitioner as of 11/08/2026. However, learned counsel for the petitioner has produced a copy of a notice under section 35(3) BNSS issued to the petitioner directing him to appear on 14/8/2026, wherein the case number has been mentioned as Fakirganj PS DBB capital, okay, 59 of 2026. Call for a comprehensive report from the IO. Made clear that in the event of till receipt of such a report, no coercive action shall be taken against the petitioner. It should also be open for the petitioner to appear before the IO pursuant to the notice received by him. Yes. Go and appear. We have protected you. Go and appear now.
Any date may be given, my, after 15th August. After
Give a
7
date.
days.
We'll give a date. Appear whenever you like. Yes.
Who's to, you know? The next day. Oblige, my lord.
May I please, your lordship? The bail application wrongly listed in AB column, my lord. Petitioner in custody today 49 days. 5.4 gram heroin has been recovered from the possession of the petitioner number 1. Petitioner number 2 is the wife of the petitioner number 2. Is 49 days, my lord. Intermediate quantity.
He did not receive, my lord.
Five 5.4 gram.
Direct recovery.
Lordship from the house. He is a addicted person as per my information, my lord. Petitioner number 1.
Allegation is of sale anyway. Wednesday.
Thought that, my lord. 49 days otherwise. Wednesday. My lord. Wednesday, my lord.
They did not receive list again on.
Like it.
Please, your lordship, my lord, this is my motion matter. I was let's see another court lordship. My lord, what is happened, my lord, page number 16 is the FI, my lord, regarding my lord, false marriage. My lord. Really happy look, my lord, page number 16, my lord. Marriage, my lord. Under
Yes.
16, my lord. I Nijora Bosumata aged about so and so, so and so, so and so. Successfully submit this complaint against the Biswajit Soikia, my lord. This is my lord, petitioner, my lord. On 15 March 2026, I meet Biswajit Soikia at a birthday party at Likabali. Thereafter, opposed me, expressed his love for me, repeatedly assured me that he would marry me. He gained my trust by making continuous promise for marriage, persuaded me to enter into a physical relationship with him. Believing his promise to be a genuine, I consented to the physical relationship solely because I believed that he would marry me. Later, I came to know that Biswajit Soikia was legally married. In fact, deliberately, intentionally concealed me from me from the very beginning, had I known that he
You are a
was-
married person.
No, my lord, my lord, this part is, my lord, I established denied lordship. My lord, what is happened, my lord, first part, my lord, I admitted lordship. What is happened, my lord? Actually, a seal of me, my lord, there is, my lord, some defense come, my lord. Basically, she wants to, my lord, she demanded to leave my parents, my lord. And she wants, after marrying, my lord, she wants in rented room, my lord. Moreover, my lord, she literally, my lord, demanded money, my lord. This is, my lord, from page number 19 onwards, my lord. I go through Google Pay, I have, my lord, paid, my lord. Lastly, my lord, kindly see, my lord, page number 31. She, my lord, lost the FIR on 7, my lord, on 5th August, I paid, my lord, 10,000, where she demanded, my lord, 50,000 for buying an iPhone lordship. I could not pay him, my lord. My lord, kindly see, my lord, my lord, I bought one judgment lordship in this regard, my lord, where, my lord, in future some defense come, my lord, this cannot be, my lord, treated as, my lord, it should be treated in defined way, my lord. Only see, so.
Heard learned counsel for the petitioner learned additional PP. Allegation under so and so. The allegation pertain to the petitioner having induced the government to enter into a physical relationship with her on the promise of marriage. However, it was later discovered by the informant that the petitioner is a married person. Learned counsel, the petitioner strongly denies that the petitioner is a married person. Submits that they were in a relationship and subsequently certain differences developed between them. Call for the CD in interim 20,000 CRT. List again on so and so appear before the IO with 10 days.
High levelers.
Production list item number 1.
Petition is allowed.
And number 2.
Petition is allowed.
Item 3.
Petition is allowed.
Item 4.
Petition is allowed and matter is remanded by.
Item 5.
Petition is dismissed.
Except to items 22 and 23.
My lord, I was supposed to take instruction regarding that matter, my lord. GR case under 498A IPC.
Yes.
I inquired, my lord, the petitioner has not received any summon till now. Online also we checked, it is said disposed of. Nature of disposal is the file has been kept.
filed. Probably, my lord, someone was earlier not served and under such circumstances it was filed. But now it is so, online it shows disposed of. And I inquired, my client has not received any summon till date. In connection with, that is why that is not mentioned.
And I have information that I have gone through the file and records. In fact, it was supposed to move today, but the mother of the girl died yesterday, so I could not. So attachment order is there. Someone was served, he did not appear, therefore attachment order was issued. But the police submitted report that there is no property in his name. So Lordship, this is not the issue. The issue is that the marriage.
Yes, that was his submission, was that different dates and places of marriage have been mentioned in the, that was.
Different affidavits, they have mentioned 3 different ways and different places. I may take your lordship for to that.
No, you
First
have
they
already
mention-
taken us, we don't
Yes,
intend
sir.
to repeat that.
Yes, yes.
I am relying on decision of the Supreme Court.
We had only adjourned this matter for that purpose,
my lord.
that is, but that is not very relevant anyway.
But my lord, that day as it was alleged that I have suppressed material facts, that's why my lord, because it was
That
not.
part we'll ignore, because
This is
you
also
have not received notice, so
relevant.
And I pray, my lord, as there are heavily they have failed to say establish in which that marriage was taken place. So, my lord, this 144 under BNSS or 125 under CRPC will not be attracted. As well as, my lord, in the other matter, my lord, domestic violence will also not come in, my lord.
May I submit? Lord?
yes.
I am relying on decision of the Supreme Court. The Supreme Court says that strict proof of marriage such as certificate or all the documents is not at all necessary. Conduct trial under section 125 of CRPC. And if the husband refused that the complainant is not his legally married wife, then it is the husband who has to prove before the trial court adducing evidence. This is the observation of the Apex Code, Lordship. The paragraph number 6.
Citation.
It is clearly says, Lordship, in Supreme Court says, in our view, validity of the marriage for the purpose of summary proceedings under section 125 CRPC is to be determined on the basis of the evidence got on record by the parties. The standard of proof of marriage in such proceeding is not as strict as required in trial of offense under section 494 of IPC. If the claimant in proceeding under section 25 of the code succeeds in showing that she and the respondent have lived together as husband and wife, the court can presume that they are legally wedded spouse. In such a situation, it is important, the party who denies the marital status can rebuke the presumption. That is, it is the onus is shifted to the husband. You will have to prove it by adducing evidence. Supreme Court repeatedly telling that because it is a disputed fact, so evidence is required. Paragraph 9 is also important. It is also relevant. Paragraph 9.
Yes, yes, we've seen that, yes.
It is to be remembered that the order passed in application under section 125 CRPC does not finally determine the rights and obligation of the parties, and the said section is enacted with a view to provide summary remedy for providing maintenance to a wife, children and parents, and for the purpose of getting his right determined, the appellant has also filed civil suit which is pending before the trial court. In such a situation, this court under the court in 1971 within bracket 3 SSC 1923 observed that maintenance under section 48 CRPC 1898 similar to the section 125 of CRPC cannot be denied where there was some evidence on which conclusion for granting maintenance could be reached. Again, the Supreme Court is telling that evidence. It is some evidence. When the question of evidence is come, then it is the matter to be placed before the trial court.
I think he had approached the trial court by civil title suit for declaration. No,
Because
no, not in this case. So that was a different case.
It is only the proceeding under section 1 to 5. And Lordship, Supreme Court also says that 1 to 5 is a welfare legislation and which cannot be decided without adducing evidences, without probing the fact. As such, the simple question, why I shall be deprived to prove whatever I have stated in my petition before the family court. I have a right to prove my statement by adducing evidence. Similarly, the husband has also the right to cross-examine me to establish his case. So on the basis of that two different date is mentioned, he is denying that I am not his legally married wife. Simply on the basis of two different date mentioned, but here is same. In this regard, the observation of Supreme Court is very much important. No strict proof is required. And if someone denies, then it is his responsibility to prove it by adducing evidence.
So the trial has not commenced.
Because there is a blockade.
There is a stay order.
Yes,
and
stay order.
Order is there.
But when they first approached this domestic violence petition they filed, there they said that they had a registered marriage. And we claimed that there was no marriage and we asked them to produce the registration certificate. Under that circumstances, we filed the first quashing petition of the domestic violence proceeding. There they came and filed a affidavit before this honorable court, and that in that affidavit they say no, it was not a registered marriage, it was a marriage held in a particular temple in somewhere nearby in the San Mari area, and there they live together as husband and wife. That was their stand initially before this honorable high court by filing a petition. Thereafter, my lord, they filed 144 petition where they say no, marriage took place at Dhemaji and they started their conjugal life at Dhemaji. And that date.
Yes, that is all right.
Yes,
You have taken us through that already.
and
That we have heard you.
thing is that the date and time when it was given, the petitioner was a student. I have enclosed his identity card also in my domestic violence proceeding. A student cannot marry.
What is the argument? The student cannot marry.
This is not a
is there a legal bar?
Yes.
If the student attained 18 years or above
No,
age, he is not
here.
supposed to marry. This argument shall not be appreciated, Lordship. Lordship, one
He was a
important
student
aspect
at that point of time. And I have categorically stated I have not attained marriageable age at that point of time.
that has to be proved
Simply
by
saying and
adducing
filing a petition,
evidences.
my lord, will not show. He has to prove, prima facie, he has to prove that there was a marriage. That prima facie thing is not in
Lordship,
this case. And
Lordship,
this
may
may be
take note one thing is that my friend repeatedly relying on the case which is almost disposed, just pending for final order in the JMFC and his entire petition, should I show? His entire petition is drafted on the basis of the case which is pending, DB case pending in the JMFC. So the JMFC case, they did not contest it. It is decided ex parte. And I have produced evidences which is appreciated by the court. Domestic incident report was appreciated by the court. All these things are appreciated and court came to the conclusion, yes, there is a domestic relationship. An interim order is also there. So if there is no domestic relationship, the court could not pass the interim order. In fact, this matter has become infructuous. Now the only question is his petition about the section 1 to 5. And 1 to 5, it is very candid and clear that strict proof, as my friend has submitted, strict proof is not required. If anybody denies that, deny the fact that there was no legal marriage, then he has to prove it before the trial court by adducing evidences. But see, why I should be deprived to prove my statement, whatever I have stated in my petition, to prove the statement by way of adducing evidences? Is there any law? Is there anything? Nothing is there. Their petition also silent. That only issue is that I have stated in 2 different places that marriage was solemnized. This is the only issue.
3 different ways.
2, 3 or 4, whatever may be. But marriage was there. And moreover, the section 1 to 5 is well for
This DV
registration.
case is now pending for what order, judgment?
Order it is.
For final order.
This fixed on 7-9.
7-9.
For
Evidence
orders.
closed. Argument done. And another thing is, Lordship, that section 1
So this petition has become infructuous. It was for questioning and staying of this, but that continued, trial continued.
There was no stay order in the
No
domestic.
stay order.
So it proceeded, but we cannot say that it has been.
No, Lordship, one important
Because
aspect is
the
that
matter is still pending. Domestic violence petition is pending, and this we have filed for quashing of that. It has not come.
Lordship, Lordship may take note of that. Whatever my friend has submitted before this honorable court, why they did not contest in the domestic violence case? They could have a better opportunities to prove that there was no domestic relationship, but they remain absent. They would have an opportunity to adduce evidence and to cross-examine the wife also to establish their case, but they remain absent. Remaining absent, straightway they have approached the High Court.
Yes. All right. So same submission with regard to DV Act case
Yes.
also.
Because we denied the marriage and they have failed to establish their marriage prima facie, so both this provision will not happen.
And my submission is this matter has become infructuous, evidence appreciated, court is satisfied, DI domestic incident report appreciated, there was a domestic relationship.
But remember in DV, the wife word is not there. Domestic relationship is only there.
But when the domestic
Marriage
relation.
is not necessary to establish marriage.
Yes,
in
yes, my lord. The
DV.
domestic relation has to be in view of
Yes.
the Rajnesh versus Neha case, my lord. That has elaborated what will be the domestic relation in case of DV. My lord, this will not come under that purview also, in my humble submission, my lord.
And this is also observed by the Supreme Court that if there is a considerable time of living relationship, it can be assumed that they are cohabited as a husband and wife. Then section 1 to 5 is applicable. This is also clear observation of the Supreme Court.
Again, it comes back to question of evidence,
Again,
whether they are in a domestic relationship or not.
Evidence,
My lord,
evidence is required.
my understanding, my lord, if I am not wrong, my lord, Rajnesh versus Neha, it says, I forgot the paragraph, it says to construe a domestic relation, certain conditions must be fulfilled.
Yes.
My lord, number one is that both the parties must have attained the age of
This
marriage.
argument is
No,
because my friend is arguing on an infructuous matter. I will object. Why you did not attend there in the court trial?
No,
court?
technically it is not infructuous as long as it is not disposed of.
They remained absent. It is true. It is
No,
established.
that is a different matter.
is different thing.
He can take a stand that this matter does not lie at all. So there is no need for me to contest this case. Please quash it. It is not at all maintainable. He can take
My lord,
that
if
stand.
lordship quashes this matter
Marriage
today,
is a different matter.
Yes.
But no, you cannot say that it has become infructuous technically as long as it is not disposed of.
Final order has not
my
been
lordship
announced.
quashes
That
it
is-
today,
that
that
is-
matter becomes, that will go, my lord. If lordship quashes the proceeding, that goes.
Yes.
if lordship quashes the proceedings, the evidence has been appreciated, that has to be challenged. That evidence are wrongly appreciated, that the evidence were inadmissible. This observation has to be given, but they remained absent.
Yes.
One thing is that my final submission, until or unless
That's it will be CFE.
evidence is adduced, no party, neither me nor he, can say that my version is correct. So it is the, it has to be proved before the trial court.
Yes, yes. Noted.
Is your lordship, if I for the petitioner appearing on behalf S. Ahmed, the lordship on the last occasion appeal was being admitted and notice was being served, notice was being issued, and no reply has been filed till date by the respondents.
Has it been served?
Yes, your lordship.
But office note says no service report has been received. Service on respondent number 2 is not yet complete.
Yes, sir. So, registry. Report is awaited, lordship.
Await, sir. Await report. Yes. Again on.
It is to your lordship. Lordship, fresh steps were taken on earlier occasion. But on the last occasion, steps were awaited for completion of service.
Well, respondent number 3 has left the place. Respondent 2, insufficient address. What about dusty service? You were allowed.
We have taken lordship.
Where is your affidavit? Have you served? No, if you had served, you have to file an affidavit. No, they have not filed. Office note says that.
Regarding service.
No affidavit of dusty service has been submitted. List again on so and so.
Pleasure, lordship.
What date is the list on? It. 28.
The appellant is convicted under section 8 of POCSO for 4 years. And he has already undergone for about 11 months, more than 11 months as on today, lordship. And earlier bail application was rejected in lordship, that your lordship will find at page 61, lordship.
They were to file objection, lordship. Right now, my learned friend said that.
They are the amicus period. They can submit orally also. Because they are not independently engaged by the informant also. And I am already on 4 years, lordship, and 11th month already he is served out. And the appeal was directed to be listed for hearing. It is not, paper book is also not prepared, lordship. There was direction for paper book. By this time, he will, lordship, serve out the sentence. And objection is required only in above 10 years cases, lordship. Even to public prosecutor is required to file.
Below 10 years, their objection is not required as per CRPC, BNS laws.
I have some small some personal difficulty. A. Fukon.
Hmm?
A. Fukon, who is representing respondent number 2, amicus curiae, is not able to. Lordship, as
Alright, Wednesday. Wednesday. Learned counsel for the applicant. Prayer is made on behalf of learned amicus curiae for adjournment on ground of personal difficulty. This is the matter again on
19.
Obliged.
Wait, please, Your Worship. But the first occasion, my lord, there was a case under 125 CRPC, my lord. That against that, my lord, the maintenance of rupees 1500 was granted. Hereafter, my lord, a DB case was filed. In that DB case, my lord, another 4000 was ordered against the petitioner before your lordship. Now what happened, my lord, that 1500 rupees I am paying, my lord. My lord, I am an unemployed person. In the meantime, what happened, my lord, in DB case, this order was passed. I challenged this order before your lordship in criminal revision 283 of 2026. In the criminal revision, my lord, my main ground is this, that as per this Rajesh and Neha, my lord.
No, what is this IA about now?
IA about, my lord, that warrant has been issued against me for non-payment in DB case, my lord. So I come against that warrant, my lord, because in criminal revision, my lord, that DB order is under challenge. And your lordship was pleased to issue notice in that case. And in the meantime, this, my lord, the order has been passed. So, my lord, my humble submission before your lordship at this stage, my lord, notice will go. And in the meantime, my lord, this operation of the NBA may be stayed. Because, my lord, I am an unemployed person. 1500 I am already paying, my lord. And she is also a working lady, my lord. Regarding my loan, my lord, there is no dispute. But she is a working lady, my lord, one after another. And another thing is, my lord, as per Rajesh and Neha, my lord, that petitioner, that the victim should not suppress that there was a proceeding. And DB case, my lord, it was discussed that yes, there was a suppression of earlier case. But thing is this, in cross, she admitted that yes, I am getting 1500. On that count, my lord, she was exonerated. And this 4000 rupees has been ordered. My lord, my humble submission before your lordship, at this stage, my lord, that impugn order may be stayed in the IA, my lord. Let notice go, my lord, let her come.
Let her come, then we'll decide to stay.
My lord.
IA so and so had Mr. To notice steps within 3 days. List again on 4 weeks.
My lord, my humble submission before your lordship, it may be observed that on returnable.
Prayer for interim order shall be considered on returnable date. If service on respondent is complete.
I will take a step by this.
Speed post.
Speed post. Oblige. Awesome.
May it please your lordship. As per instruction, lordship, a notice has been served to respondent number 1, but the service report is awaited.
May I please your lordship, we will file the wakalatnama today itself for this present case.
Sole respondent.
Yes, lordship, respondent number 1.
I'm representing Narayan Chandra Sarkar.
Now, is it the sole respondent or any other respondent is there?
State is there.
State is there. So you're respondent number 2. Huh?
State is a formal party. And
Okay. Learned counsel for the petitioner. You are Miss,
My Lordship, I am representing Narayan Chandra Sarkar.
yes, your name?
Jagriti Priyadashini Saikia.
Did you get that? No.
Jagriti, JP Saikia.
MS JP Swagia has entered, appeared on behalf of the respondent number 2 and submitted that the Wagalatnama will be submitted in the course of the day. Hence, place the matter again on. Two. I think state is the first respondent, I think. Yes.
State is the second, respondent
Second.
number 2. Yes.
Okay, then respondent 1.
I humbly request the opposite counsel to serve as the petition so that we can file the reply.
But you didn't get the petition with the notice.
The notice has been served already.
All right, you furnish one copy. Petitioner to serve copy of the petition upon learned counsel for respondent number 1. Yes.
Kindly pray to fix this matter after 4 weeks.
I think that has been given. Yes, next column.
Election.
My lord, in this case, my lord, before they start, my lord, yes, I mean one thing, my lord, they have filed this criminal petition for passing of the FIR, my lord. So in the meantime, my lord, my investigation completed, search is submitted, my lord. They have not challenged the search sheet, my lord.
Lordship, we have filed this petition before the search sheet got submitted to the trial court. Lordship. The date of filing this petition is before the search sheet has been done. Lordship.
So what will you file additional affidavit?
Sorry.
Challenging the charge sheet.
No, we did not challenge the charge sheet. As because we have already filed this petition before the charge sheet got submitted in. And
Yes.
today the informant is ready to do the PC Lordship.
Because of the subsequent development, are you not required to
Informant herself.
charge sheet?
Informant herself is not ready to proceed with the case, Lordship. And she is ready to do the go for the PC Lordship. She is in online in this.
Then, my lord, scan copy may be called for, my lord. So there are several complaints, my lord, against this, my lord, petitioner. Not only this informant, my lord.
Not concerned with other ones. This is for quashing of the FIR.
Yes, Lordship. At that time, Sachit was not submitted to the trial.
Mhm.
At the moment we filed this petition, that time Sachit was not submitted to the
In
trial.
fact, my lord, they filed this application in the month of May, my lord. And search is submitted in the month of June, my lord. It's not that, my lord, while they filed this application, search was not there, my lord. But there, my lord, it may not be in their knowledge, my lord. The search is
They
submitted
filed in May, charge sheet was filed in June, then how it will be there?
is why, my lord.
In the month of May, we have filed this quashing petition, Lordship.
So it was filed subsequently. Charge sheet was filed subsequently.
Yes, Lordship.
It's better you bring on record the charge sheet. Otherwise, but if we set aside the FIR, then cause the FIR, then any subsequent proceedings will also get closed. Let us finish this then. What was the allegation?
I take act where there, FIR was.
Page number 13, my lord.
Page number 13, yes.
That was the case. What is the offense registered? No, let us do one thing because we don't know what is there in the charge sheet. If we say, we have to mention the sections. But let us have her on VC and take her views so that it is not necessary she appears on a subsequent date. We'll record her and then you bring on record the charge sheet or we can call for the.
Yeah, my lord, can this year maybe call?
Yes, yes, we can do that. Yes, get her on VC.
Yes.
Yes, what is your name, ma'am?
Machile. Pame.
Okay, where are you speaking from?
Pune.
You're in Pune now. Yes.
Yes.
So you lost this FIR earlier?
Yes, I lodged this FIR earlier in the year.
Yes. So now you are willing to compromise the case?
Yes.
You don't want to pursue the case anymore?
No.
Okay. So you're doing this of your own will? Ma'am?
Yeah.
Nobody's
Yes.
pressurizing you?
No, sir.
All right. Thank you. That will be all.
Okay, thank you.
Is heard learned counsel for the petitioner. Learned additional PP. Learned also heard the informant stroke victim in person appearing through VC from Pune. The informant stroke victim has clearly stated that she does not want to pursue the case and accordingly the proceedings may be quashed. She has also stated that she has not been pressurized by anybody and has indicated her willingness to compromise out of her own will. There are learned additional PP submits that in the meantime the charge sheet has been filed. For the
Charge sheet number, my lord. Charge sheet number is 18/2026, dated 9/6/2026.
and it would be appropriate to call for the same before passing final orders. Accordingly, call for the scanned copy of the aforesaid charge sheet. Is the matter again on?
Sir, the matter is fixed on 24th of this month in trial court, Lordship. If it's possible, a bit earlier.
In view of the possible compromise, the learned trial court what is it fixed for CC for appearance?
CC, yeah. Copy already been served to the.
It can take time on that day.
They defer consideration of charge.
Your Lordship, in Haflong, they always have 3 cases for a day. So, they always, magistrate used to say, come early, come early. They used to give 1 week time only, that's it. Then we have taken 10 days time, Lordship. When we the accused, Lordship.
Until further orders. Just again on since.
I don't know. Deeply blessed.
Standing at
Lordship, as per order dated 21/11/25, appeal has been admitted by your Lordship. Have taken a state, but Mr. has not been.
What is this, POCSO?
Lordship, NI Act under.
NI Act?
Lordship. Yes, it's
Way back in February, better you take fresh steps.
Lordship. Lordship, upon respondent number 2 and 4, we will take upon fresh steps upon purgent address, their purgent address. They are shifted from another, they are shifted to another place. We have get instruction. Yes. Respondent number 2 and 4, your Lordship.
Learned counsel for the appellant submits that he will take fresh steps upon the respondents number 2, 3, 4, and 5 as per current address. Just again on.
Obliged.